What's up, everybody, and welcome in to another video here on The Lawyer You Know, breaking down the legal cases you all want to talk about. And yes, it may be the case most of you came to this channel on or are interested in. And yes, that is Depp v. Heard. We're going to break down basically an outline of what each side is planning to argue in their appellate brief. And I will go through line by line each argument and talk about which ones I think have the most merits or the best chance of being successful on appeal. But first, thank you, Nicole, for my first golf shirt sent from Greece, or from a Greek course, the Crete Golf Club here, proven by the Greek flag here on the side. And I'm not, it is kind of like a muscle shirt because it's a little snug here, even though it is a lot large. They just make them a little smaller in Greece, so we feel better about ourselves, so the men can really feel like big shots. So it's a little bit snug, but it's cool. It's good enough. It works. My friends will make fun of me for it being too tight, I'm sure, which is always fun. But thank you, Nicole, for the early birthday present and for all of the awesome people sending me shirts from around the world. It's been a really fun ride and crazy to see these shirts. Don't feel like you have to at all. But I really appreciate this one. Is really cool. And so I'm sporting it in the video today, talking Depp v. Heard. So let's get into it. We are going to start with Amber Heard's appellate issues. Amber Heard, appellant's designation of assignments of error. Okay, that's what we're talking about. Where did the court err? Comes now. Appellant, Amber lawyer Heard by and through their counsel and designates following as her assignments of error pursuant to Rule 5A.25, which is basically you're required to make an index, basically, of a list of the issues that are going to be in your appellate brief. So let's get to it. Number one, trial court erred in declining to dismiss the action on the grounds of forum nonconvenience. What is forum nonconvenience? What I like to think of it and how it helped me in law school is this forum is not very convenient. But what it actually means is this is the wrong venue for the case. This is the argument that the case should have been heard in California, which may have been different than the fact that it was heard in Virginia. So this is the first argument made by Amber Heard, and I think she has about 0% chance of winning this. We've been over this many times. We've read through the case law, and I really think that it was totally appropriate to have this case in Virginia. Number two, the trial court erred in denying the supplemental plea in bar and in ruling that the November 20, 2022 judgment of the UK High Court of Justice Queen's Bench Division in Depp v. Heard does not foreclose Mr. Depp's claims, basically arguing res judicata. This has already been litigated. We already have our answer by a similarly situated court in a similar situation. Again, this is a loss. That's an L. You're going to eat the L on this one. It's not res judicata, different parties, different issues, different statements. There's just no way that one wins. Number three, the trial court erred in denying the demurrer and plea in bar and in ruling as a matter of law that the three allegedly defamatory statements in the challenged op-ed are A, actionable as statements of fact rather than non-actionable expressions of opinion, and B, actionable as defamation by implication. I'm not going to be so quick to say they're going to need an L on this one, because this, I think, is Amber Heard and her team's best argument. We talked about it throughout the whole trial. This is why defamation is difficult. Opinions are protected. Is this an opinion? And I think that's the way the trial team should have gone throughout the whole trial, that this was an opinion based on what she went through and not proving that she never did anything wrong, which is what the trial kind of turned into. So while I think her appellate lawyers will focus on this and this will be their best argument, I think her trial counsel failed her in focusing or failing to focus on this issue. Number four, the trial court erred in excluding from evidence at trial the November 2nd, 2020 judgment of the UK High Court. And the answer to that is, that's an L. Because in some other court against some other defendant, Johnny Depp filed a defamation claim and lost. That just would have made this jury think, well, maybe he just does this all the time and loses all the time. Propensity type stuff, which is inadmissible. It was different. The standards were different. The country is different. The laws are different. Everything's different. And if they heard a judge decide a certain way, it does not tend to prove or disprove anything in this case. Therefore, I think that was absolutely properly excluded, and I think that's an L. 5, the trial court erred in excluding from evidence at trial medical records, including Ms. Heard's contemporaneous communications with medical providers such as Dr. This, Ms. That. We lost our camera here. Let's get back in. All right, we're back. So, all these doctors, friends, and family about the interactions with Mr. Depp. It's literally explained why they're going to lose this one in number 5, which is, in fact, it's all hearsay. This is a loss. So it's going to be a loss. That stuff was properly excluded, in my opinion. Now, maybe they're going to argue certain medical documentation should have come in because it was contemporaneous and things like that. But overall, most of this is hearsay. Most of it should have come out. I don't think it's going to be a reversible error, but maybe we'll give them a 10% chance of that one working. Number 6, the trial court erred in admitting evidence at trial related to Ms. Heard's pledge to donate money to charity and evidence related to Ms. Heard's alleged abuse of third parties. Well, when you have cases like this, sometimes when you accuse somebody else of being the aggressor, there can be evidence that you are actually the aggressor. When your credibility is at issue and you take the stand, if you have lied or made other statements that are impeachable, and they can be impeached by news programs and letters and things that you've signed, that's usually going to come in. And they know this whole pledge versus donation, which Ms. Heard says is the same thing, but we all called baloney on it pretty early on. They know that that hurts her, which is why that's a major issue that they think affected her credibility in front of the jury. And I think it did. I think they're right, but I don't think it was reversible error. I think that should have come in. Number 7, the trial court erred in excluding evidence at trial of Mr. Depp's reputation as it existed prior to the publication of the challenged op-ed and after the op-ed was published. Really? They excluded evidence of Johnny Depp's reputation? How many headlines did we hear? How much drug abuse and alcohol abuse did we hear? I heard more than I ever wanted to hear. I could have done with 1/10 of it, and I still would have understood that Johnny Depp had issues prior to this op-ed. So I assume they're speaking of something specific, but I don't know what it was, and I heard plenty of his prior reputation. The trial court erred, number 8, in sustaining an objection during cross-examination of Mr. Depp to a question about truth of one of the allegedly defamatory statements on the grounds that it called for a legal conclusion. I would have to see the specific statement. I don't remember which one they're referencing, so I'm going to leave this one open as I'm not sure. Number 9, the trial court erred in allowing Mr. Depp to argue or suggest at trial that the jury could award damages based on statements or conduct occurring prior to the publication of the challenged op-ed. And this one actually, I think, may have some merit because it was very confusing throughout the trial as to the timing of certain things, what the jury was allowed to do, was not allowed to do, was supposed to do, was not supposed to do. And to me, this falls a bit on Amber Heard's trial counsel. It's their job to explain to the jury what all this means because these words were in there in the jury instructions. They heard these words and they still awarded the damages the way they did. So I think this was partially on Amber's trial counsel. Number 10, trial court erred in allowing Mr. Depp to argue or suggest at trial and the jury to consider whether the allegedly defamatory statements in the challenge op-ed were republications of statements Ms. Heard made in 2016 in connection with the domestic violence temporary restraining order she obtained against Mr. Depp. This provided appropriate context, was basically included by reference. This is how we knew who she was talking about. She referenced the date 2 years ago. I don't understand how you would keep this part out of trial or how it was reversible error on appeal. The trial court, on number 11, which rejected proposed jury instruction CC and properly instructed the jury on actual malice. We've been over the case law on this. We read some of the motions on this. I think it's an L. Now, 12 through 16 are all the trial court erred in denying the motion to strike and set aside the jury's verdict. We did an entire video on that, dove into each of their arguments, explained why we think they had no merit. We knew 100% chance they weren't going to win when Judge A was making the decision because she is the trial court. But now they're making these arguments to the court above, which is their legal right. We will see if the appellate court sees any of these differently than we saw them or Judge A saw them. So that's Amber Heard's argument. No real surprises. in my opinion, and only a couple of them even have a chance to be meritorious. But let's look at Johnny Depp's. She had a string, right? She had 16 of them. Johnny Depp, on the other hand, and his attorneys, I've got a lot of windows here. I got to pick the right one. Yeah. Johnny Depp and his attorneys decided to just pick a couple and pick their strongest arguments that I was pounding the table for throughout the entire trial and after the verdict. When a lot of people said, oh, I can understand how they came to that decision. Even Johnny Depp's lawyers in interviews said, I can understand how they came to that decision. I was like, but how? Waldman's statement. So now any statement a lawyer makes can be defamation on behalf of his client. I don't think that's a precedent we want to set. That's basically what they're arguing here. Number one, the trial court erred by denying one, Mr. Depp's motion for summary judgment as to appellee Amber Heard's counterclaim and Mr. Depp's motion to strike the evidence as to Ms. Heard's counterclaim. A, Mr. Waldman is an independent contractor, not an employee agent, and Mr. Depp is not liable for Mr. Waldman's allegedly tortious conduct as a matter of law. The statements by non-party Adam Waldman that are the subject of Ms. Heard's. Now we got to find the next one. Let's see if we can get as lucky as we did this time. Yeah. Ms. Heard's counterclaim are not actionable statements sufficient to support a claim for defamation. Ms. Heard failed to present any clear and convincing evidence that Mr. Waldman made the counterclaim statements with actual malice. The trial court, this is number two, erred in refusing Mr. Depp's proposed jury instruction, numbers 22, 23, 24, as to whether Mr. Waldman was acting as an independent contractor when he made the counterclaim statements. And they cite in the record where they actually preserved this issue for appeal, which they did so properly. And last page. The number three, the trial court erred in excluding from evidence the full unredacted versions of Mr. Depp's exhibit numbers, those three exhibit numbers, which are copies of the news articles in which the counterclaim statements appeared, instead admitting only redacted versions that show the counterclaim statements out of context. So again, all Depp's team focuses on is Adam Waldman's statements. That he's an independent contractor, a lawyer, not an agent, not an employee directed to make these statements. Depp cannot be held accountable for those statements. Those are Waldman statements and Waldman statements alone based on what Waldman knows from more people than just Johnny Depp. And I don't think they presented any evidence that Johnny Depp instructed him to do that. So I actually think that's a great argument. That is really their best and only argument. And that's all that they put forth in their appeal, which is a very smart way to do it. Because if you just throw a bunch of slop up against the wall, the appellate court's going to be like, no. And it's a lot harder to win on one. If you just pick one, the appellate court may think about it a little more closely. Now, it depends on what you have, what case you have, how many arguments you have. You don't want to leave any good arguments out. I'm not saying you can only pick one, but I think it was smart for Johnny Depp's team to focus on their best argument. And Amber Heard has a couple that may have some merit, but some that are just easy L's, in my opinion, for the appellate court to determine. Let me know what you think. Who do you think has the better argument? If you're not subscribed to the channel already, hit that subscribe button. Like the video if you still enjoy the Depp v. Heard comment. Let me know if you have content. Let me know if you have any comments or questions. Post them below. Thanks for joining me. That's all I've got today.